20 being withdrawn.
No. No.
New clause 20 by leave withdrawn. We now come to new clause 21. Any reeve to move new clause 21?
Thank you, Mrs Murray. I rise to speak to new clause 21. Under the law, if a father is found guilty of killing his children's mother, he retains parental responsibility over the children. This means that after ending their mother's life and destroying the children's lives, these killers still have power over their children. Power to be involved in decisions affecting their lives. Power to continue their controlling and abusive behaviour over the family of their victim. New clause 21 would end this dreadful situation. It would reverse the onus being on the victim's family to prove, often through protracted legal proceedings, why the perpetrator's parental responsibility should be revoked. Instead, the killer's parental responsibility for the period that they are in prison would be automatically removed, and the onus would be placed on them to go through the legal hoops to prove that they deserve that responsibility. This would apply to all those who have been found guilty of the murder or voluntary manslaughter of the other parent. The loss of a parent to violence is something which creates deep trauma. While we have no official figures on how many children lose their mothers in this way, we do know that 2 women are killed by their partners or former partner each week. And one trauma specialist I spoke with, who has worked with hundreds of children whose mother was killed by their father, estimates around 50 mothers are killed by fathers per year. In these cases, the children will not just be dealing with grief at the loss of their parent, and it is almost always the mother who is the victim in these cases, but they're also dealing with feelings of anger, shame and confusion that accompany having a father who has committed such an abhorrent act. But retaining parental responsibility allows these men to continue to exercise control over the children and surviving family from their prison cell. This results in the indefensible situation where their permission must be sought regarding things like the children's schooling, medical treatment, and before they can be taken abroad. This forces the children's carers, who are often the only stability the children have left, to engage with the killer and their wishes, which can be hugely distressing and in turn potentially destabilise the children's recovery. Some abusive fathers have even tried to block maternal family members from gaining custody of the children they love, leaving the children to grow up in the care system instead. This has left some families unable to see their loved nieces, nephews or grandchildren for months on end, as legal battles have gone through the courts at the exact same time when they are needed most to support them. The fact that a convicted killer's parental responsibility cannot be suspended without protracted legal battles is a huge injustice. What greater dereliction of duty towards a child can there be than to rob them of their mother and burden them with a lifetime of trauma? Many are raised knowing that the perpetrator retains intimate knowledge and access to their lives, and this undermines their recovery. For some, that results in fear they may themselves be in danger, and for others, it results in decisions being made not in their best interests, but rather to deprive them of opportunities out of sheer spite. Children Heard and Seen, a charity that supports children impacted by parental imprisonment, reports that the continuation of their father retaining rights over them is a significant traumatising factor in those children's lives. Children need stability, and their guardians having to fight in the family court runs counter to this. As I've outlined, our new clause would end this. I now want to turn to the case that has helped shape this new clause, and that is the case of Jade Ward. Jade was 27 and she'd recently left her former partner when she was murdered by him in her home. Their 4 young sons were all in the house at the time. Jade's killer was given a life sentence last year, with the judge calling the attack merciless. But Jade's family were horrified to find that their daughter's killer retained rights over the children. Jade's parents said her killer started to cause ripples not long after being sentenced, asking to see the boys' school reports and their attendance notes. Then they were informed by social workers that if they wanted to take the children on holiday, they would have to be consulted first and that he still had decisions over medical treatment too. Speaking to this, Jade's mother said he had lost control of Jade, so he did what he did. And now he has still got control because he is controlling the boys and controlling us. It is horrific. He is in prison, but his presence is still looming. Any rights should have been taken away from him the moment he took away their mother. You cannot put into words the added worry and stress because of him. It means we still can't move on. Jade's family have campaigned tirelessly for a change in the law, known as Jade's Law, so that no one else in their situation has to endure the added pain of being faced with the killer like they have been. And this is the clause I lay before the committee today. I've met Jade's family, including her mum, Karen, and dad, Paul. I was introduced to them by their Member of Parliament, the Right Honourable Mark Tarmy, who has campaigned tirelessly on their behalf. Karen and Paul are determined to give the 4 boys the best life they can, but they are hampered in this by the knowledge that the man who killed Jade still has a presence in their lives via his parental responsibility. Speaking recently on this, they said, the 4 boys need new passport. He is going to take as long as he can to agree to the boys having passports. Medical conditions, he's got a right to know. He's recently asked for photos of the boys, and it's the boys who have said no to that.
Just as I'm listening to her, I just wonder if she agrees with me that if you were to walk up to anybody in the street and ask them if this was the case, that a murderous father could decide whether their children could go on holiday, they would think that we were mad to suggest it, and yet it is so clearly the case.
I thank my honourable friend for that, and I've spoken to countless people about this situation, and frankly when you say that a dad from their prison cell can retain parental responsibility when they've killed the kid's mum, they just look aghast. They can't make sense of it. It doesn't make sense, and that's why this new clause is so important. And I want to pay tribute. I'll give way.
I'm grateful to her, and I share the sort of general point that she's making, but surely there are powers in social services and also in the courts to completely remove the parental responsibility in question here, and isn't that something that should be exercised? But can't you imagine also that there could be a case where a mother who'd been brutalised over a period, lost control, or perhaps just defended herself so vigorously that it became a manslaughter. But in circumstances like that, I mean, surely you could imagine that her parents might be looking after the child. She might want to see the school reports.
In relation to the first point, yes, families can go through the family courts to get a special guardianship order. I'll say a little bit more about that later. But it puts the onus on the victims' families to go through protracted and costly and often opaque family law processes in order for that to happen. And that can take years. And whilst that goes on, but parental responsibility remains there. So whilst that goes on, the dad still has a say. In relation to the second, but they're not heard urgently. It takes years, as it has done, as it is doing in the case of Jade Ward and other people that survivors' families that I've spoken to. In relation to the second point, I will go on to speak about how those people are specifically protected in this amendment under this new clause. Under this new clause, people that are convicted of manslaughter, but where the conviction arises in circumstances where there's a defence of loss of control or diminished responsibility, and at the time of the offence, they were subjected to coercive or controlling behaviour by the person that they've killed, then they wouldn't be caught by this new clause. So there is specific carve-out, but I'll talk a little bit more about that as I go on. I just want to end what I was saying about Jade Ward by paying tribute to her family in highlighting the situation and trying to stop other families facing the same suffering as they had. And I want to talk about the case of Mum Tahina Janet, known as Rumour, because I think her case also outlines the injustice occurring. Rumour was murdered by her violent ex-husband. On hearing the news, Rumour's niece, the renowned children's author Anjali Ralph, went straight to the house to find the children, but they had already been taken straight from school into foster care. They weren't allowed to know where the children were or make contact with them, whilst the killer from his jail cell was given the phone number of the foster parent and was allowed to make contact with them and sending them letters. This is despite Rumour turning to Anjali and her mother for help when she fled with her children to a refuge 5 years earlier. Anjali said, "We saw those kids every other day. Our home was a refuge for them. We'd watch films with them and take them on holiday. They were part of our family. We didn't see the children for over a year. After we were finally reunited with them, they asked us questions and gave us hints about the lies they were being told in those letters. Lies that tried to justify his murder of their mother. That youthful confidence was sucked out of them. And of course, they had trouble trusting us again. Why would they?" Commenting on the current situation, she said, "Until it happens to you, you don't know how broken the system is. You don't know it's geared towards this violent person who has all the protections and all the rights. There's no justice. Justice isn't the right name for this system." For Anjali's family, new Clause 21 to change the law on parental responsibility would be a step towards justice. Now, there is a school of thought that children always benefit from contact with their parent, but this is contrary to the available evidence. I've met with Diane Clark, whose mother was killed in 1978 when Diane was just 10. Her father was charged with murder, which he denied, but admitted manslaughter. He was sentenced at Birmingham Crown Court to just 3 years in prison. When he was released, Diane was sent to live with him. She told me that at the time she felt that this was what she wanted, yearning for a normal family setup. But as a child, she did not recognise the domestic abuse she had witnessed for what it was, and that she had been groomed by her dad to disrespect her mum. Only now, as an adult, does she realise the further harm inflicted upon her by this living arrangement. She says she realises that she lived in fear that she would anger him and he would kill her too. And let us be clear, this was not an irrational fear, given he had already killed someone he claimed to love. New Clause 21 would deliver protections for cases like Diane's, as it contains provisions for those convicted of voluntary manslaughter to have their parental responsibility suspended. This is necessary as so many cases of domestic homicide result in a manslaughter rather than a murder conviction. This is often despite long histories of domestic abuse featuring in these cases. Take, for example, the case of Joanna Simpson. She was killed by her estranged husband, Robert Brown, in 2010. The attack began when Brown was returning their 2 children, aged 9 and 10, after a half-term visit. Brown used a hammer he'd packed in the children's bag and bludgeoned Joanna repeatedly. He then put her body in the car with the children in it and took her to the site of a pre-drug grave where he buried her. Joanna's friends and family all describe this killing as taking place in the context of long-term abuse. But Brown was convicted of manslaughter rather than murder. I believe it is vital that killers like Robert Brown are prevented from causing more harm to their children, regardless of what the conviction for killing ends up being. And new Clause 21 would ensure this. All the cases that I've referred to involve men that have killed women. However, it's right to acknowledge that there are some women in prison for manslaughter, having killed their partner after suffering years of domestic abuse, the point that the Right Honourable Gentleman was making. We recognise the very specific nature of those crimes and that in such circumstances the risk to the children presented by the killer is not the same. Therefore, within new Clause 21, we have included an exemption where a manslaughter conviction that was made on the grounds of loss of control or diminished responsibility and the prisoner had, on the balance of probabilities, been a victim of coercive and controlling behaviour by the person killed at or near to the time of the killing. In these rare cases, I do not consider that the mother should automatically lose their parental responsibility, and that is why new Clause 21 contains an exemption for this. Turning to the current system, I appreciate that new guardians can already seek a special guardianship order over the children, meaning that their parental responsibility would trump the perpetrators, although they would still need to consult him on some things and would not be able to do certain important things without his consent. However, this places an extra burden on the family in terms of legal proceedings, and given the abysmal court delays, this is another hurdle for a family who has already been through legal proceedings in the criminal court. I also understand the family can seek an adoption order. However, this can feel uncomfortable for families, as it legally alters the relationship between the children if they are with family. For example, if they're adopted by their grandmother, she legally becomes their mother, and their birth mother legally becomes their deceased sister. But this is beside the point. As Anjali says, why do we even think murderers should have parental responsibility? They forfeited that responsibility when they killed their children's mother. It's beyond logic. New Clause 21 would remove the burden of lengthy, stressful proceedings in the family court and give children the security they so desperately need that their new guardians have responsibility for them and that they are safe. To conclude, the research is clear that adverse childhood experiences have a huge impact on how children grow and develop. New Clause 21 is about doing what is best for the children left behind, safeguarding their rights, protecting them from abusers, and trying to give them the best possible means to thrive. It is about valuing the rights of children over those of abusers. 1 year on from the petition for Jade's Law, it's indefensible that men who kill their partners, often after long periods of abuse, are still able to exercise control over the surviving children and their guardians from their prison cell. I note the Justice Secretary's comments today outlining his support after months of campaigning this from Labour. I also note his comment that he is looking to find a quicker way to cut off parental rights for these killers. Today is that opportunity with New Clause 21. By voting for it, we can end this indefensible situation and truly make this a victims' bill. Failing to do so is a vote for more delay, leaving vulnerable children unprotected and victims' families having to fight through the backlogged courts. Therefore, I very much hope that members opposite will vote to support Jade's Law today.
Minister. Prisoners, suspension of parental responsibility.
The question is that New Clause 21 be read a second time. Minister.
Thank you very much, Mrs Murray. And looking at the right honourable lady, this new clause seeks the automatic suspension of parental responsibility in the tragic circumstances where one parent of a child has been convicted of murdering or committing voluntary manslaughter of the other for the term of their imprisonment for this offence. Let me please start by saying I do, of course, have the deepest sympathy for families dealing with such a tragic event, including, of course, the family of Jade Ward, who've campaigned bravely and tenaciously for this change to be made. The Honourable Lady, the Shadow Minister, and I debated this issue in November of last year in Westminster Hall, following which the Right Honourable Member for Allen and Deeside introduced me to Jade's parents, who were there to listen to that debate. And I have to say, and I suspect that this view will be shared by the Shadow Minister, I think everyone in that room was struck by their quiet dignity in the face of everything they've had to put up with, and while campaigning, and everything they've had to endure. Strengthening measures to ensure the safety of children and vulnerable parents continues to be a top priority for this government and something we remain deeply committed to. I agree that in such tragic circumstances, family members who are stepping into care for the child or children should be better supported, and that fundamentally an abusive parent who has committed such a terrible offence should not be able to use family court proceedings as a further way of exerting control or indeed tormenting a tragically bereaved family. Now, as the Lord Chancellor has stated in the Sun today, it should, and I quote, "It should be presumed that when one parent murders another, denying their child of a loving parent, they should not have the right to make decisions on that child's life." End quote. Now, I agree with the Lord Chancellor, and in doing that, he was clearly setting out the view of His Majesty's government, and it's now a matter of how that intent that he has set out is achieved. Now, as the Lord Chancellor stated, there will of course be exceptions, as I think the Honourable Lady's amendment recognises, like victims of domestic violence and domestic abuse who lash out after years of that abuse where automatic restriction would not be appropriate, but restricting this right should be the norm. It is the right time this is taken. Time is taken to properly look at the options, however, to ensure exceptions. And I will come on to the legal reasons in the light of a recent case in a minute. But let me make a little progress, and I will give way to the Shadow Minister. To ensure exceptions are captured too, and we're looking for the quickest way to resolve this, and the most appropriate vehicle, the Shadow Minister would say we have one in front of us as we sit in this room today, and that may yet prove the case. However, our challenge is that we don't believe this new clause, as currently proposed, is the right route to remedy this situation. Now, the overarching principle of the Children Act 1989, as has been alluded to, is that decisions by the family court should always be made in the best interest of the child. Now, this is an incredibly important principle which we should seek to protect. The introduction of a provision requiring the automatic suspension of parental responsibility potentially runs counter to this if without some judicial engagement or wrong. Now, decisions about removing or restricting parental responsibility are quite rightly extremely serious. So it's vital that judges are able to have an engagement with that process, in whichever form, to make decisions which are specific to each child and their circumstances. So we just need to make sure that any change to the law in this area doesn't override this principle or, and this is the key legal point, potentially breach the rights of the child or children concerned under ECHR. And more work does need to be done to assess the potential implications in this, in the light of the recent court judgment, which I'll come on to, of course.
I thank the honourable gentleman. It's good that they're caring, that he is referencing European human rights law, which parts of this bill seeks to undermine. It's good to see that this one he doesn't want to disassociate from. I stand before you. I have to say I cannot hear the excuse that this is going to take more time, because the first case of a murderer who was given parental responsibility was raised in this House in 2016 by the member for Hove in a debate in which was then the Prisons and Sentencing Bill, if anyone can remember that, before it was prorogued and then blocked. It was promised that it would be put into that bill in 2016, which fell at an election, which it was then promised again that it would be put in the domestic abuse bill, which then again fell because it was prorogued. We were promised then from the harms review in 2019 that it would be coming down the line. I am sorry, I cannot sit here and hear this needs more looking at. We have been looking for years.
Well, I'm grateful to the Shadow Minister, but I will go on to explain why I believe that the drafting of this would not necessarily be appropriate. Just to her plan, I can reassure her that there are no plans to prorogue or dissolve in the immediate future that I am aware of. I'd also like to make clear that the courts do have the power to seriously restrict the exercise of parental responsibility when it's in the child's best interest. I hear the points made by the Shadow Minister in respect to that process. And I draw members' attention to the very recent Court of Appeal judgment, which I was coming to in the case of Re A, regarding parental responsibility. Now, in this judgment, the President of the Family Division confirmed that Parliament has already given the Court the power to empty a father's parental responsibility of all content and to prevent them from making any future applications to the Court, regardless of the marital status of the parents or how parental responsibility was acquired. Courts can and do make use of this power where it's appropriate to do so. But crucially, they are able to do so considering all the unique circumstances of the individual case, with the child's best interest at the heart of their decision. This clause would potentially remove that ability, but I do take the point, the underlying point made by the Shadow Minister, which is just about how re-traumatising and how traumatic going through the family court in that context can be. Now, as I said earlier, I do have huge sympathy for the aims of this amendment, particularly in respect of the processes and procedures which bereaved families have to go through in order to achieve the result they desire. And we are committed to taking action to address this issue, as the Lord Chancellor has unequivocally set out. Now, in response to the Ward Families' calls for reform, we've already asked the Family Procedure Rule Committee in the interim to make the court process less time-consuming and more straightforward for families applying for special guardianship orders and other orders to restrict the exercise of parental responsibility in these or similar circumstances. The committee is currently actively considering what changes can be made to deliver this, and as of the 1st of May, the government also extended the scope of legal aid for making those special guardianship orders. This means that where in private family proceedings an individual wishes to become a special guardian, they can receive the legally aided advice and representation to help them do this, subject to a means test. But I do agree there is more that can and should be done. That is why we are actively working on what changes could be made to the law on parental responsibility to rectify the position which the Ward family have highlighted throughout their campaign, while seeking to avoid any unintended or perverse consequences from that. We need to fully consider the recent Court of Appeal judgment in the Re-A case as part of this. I am very concerned about the risk that an automatic suspension of parental responsibility could inadvertently be deemed to breach the child's rights under Articles 6 and 8 of the ECHR, leading to potentially legal action or undermining what we're all trying to resolve here with minimal legal challenge. It is better we take the intervening months to carefully address the right approach in the light of that judgment, to return, hopefully swiftly, with a fully drafted and carefully considered proposal that guarantees the core principle of the Children Act, that the family court should always have the best interest of the child at heart, but also seeking to address the underlying point, the underlying intention of the Shadow Minister's amendment. Now, this amendment has, I think everyone could agree, an entirely, one would hope, noble and uncontroversial aim. We all have a huge amount of sympathy for families in these circumstances and want to do as much as possible to support them. And I'm happy to work with the Honourable Lady on this if she so wishes. As I say, I would repeat the words of the Lord Chancellor, which is, and sets out the government position, it should be presumed that when one parent murders another, denying their child of a loving parent, they should not have the right to make decisions on that child's life. I have to say, in response to the final point made by the Shadow Minister, and I tend to agree with her a lot of the time, not all the time, but a lot of the time, I disagree with her in that a vote not voting for an amendment is not a vote for doing nothing or a vote to reject a solution that works. It would be a vote for taking the time to get it right.
Andy Reid.
Thank you, Mrs. Murray. And whilst I've listened to what the Minister has had to say, the government have had ample time to bring forward proposals on this.
To this bill.
A new clause could have been presented by the government to this bill. As my honourable friend, member for Birmingham Yardley, has said, it has been raised since as far back as 2016. We had the debate last November, so I do feel as the government has had more than enough time to bring forward proposals. There is a proposal on the table today to end this once and for all, and that is why I will move new clause 21 to a vote.
The question is that new clause 21 be read a second time. As many as are of that opinion say aye.
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 To the contrary, no.
No.
Division.
Division 11.
Lock the doors. Lock the doors.
Edward Dark.
No.
Siobhan Bailey. Aaron Bell.
No.
Rob Butler.
No.
Sarah Champion.
Aye.
Elliot Colvin. Janet Davey.
Aye.
Maria Eagle.
Aye.
Sir Oliver Heald.
No.
Faye Jones.
No.
Anna McMurrin.
Aye.
Leah Nietzsche. Jess Phillips.
Aye.
Ellie Reeves.
Aye.
Maggie Throop.
No.
The ayes were 6, the noes were 9, so the noes have it unlocked. We now come to new clauses